The U.S. Supreme Court seems open to the idea that lower courts went too far in blocking Donald Trump's order to end birthright citizenship. Now, Justice heard arguments earlier. At issue is whether a lower court can, on its own, issue a nationwide injunction. The court seems open to backing the president on this one, even as they acknowledge practical issues of the administration's policies. James Sample is a law professor at Hofstra University, and he joins me now. Really grateful to have you on board here as we continue to try and parse the arguments today in front of the Supreme Court. What did we learn about how the justices may be looking at this case?
It's great to be with you, Paula. There are principled arguments and principled, non-ideological, non-results-oriented concerns about nationwide or so-called universal injunctions issued by federal district courts in an isolated federal district, but applying against the entire nation or in the entire nation. The contrary version of that is that the government is the defendant in all of these cases, and the government of the United States is the government of the United States in every district. And so when an injunction tells the government that what the government is doing is illegal, stop doing that illegal thing, that is, in effect, an injunction against the government everywhere. And so in that sense, birthright citizenship is either going to be enjoined, the government's policy on birthright citizenship, the executive order, is either going to be enjoined on a nationwide basis, or it's going to have to be pressed one by individual plaintiffs in every single jurisdiction around the country. Neither one of those is perfect, but up until today, the longstanding practice and the law, the absolutely clear law on the substance of the question, was that the nationwide injunction practice was the way in which that would be addressed. So today, the court did seem sympathetic to the idea that isolated universal injunctions from isolated judges are potentially a concern. But on the other hand, birthright citizenship is the classic case where they are valuable because you don't want citizenship to mean different things in different places.
Yeah, and to be clear, that means that you could be a citizen in the state of New York, where I am right now, and not be a citizen if you go to the state of Nevada, for instance. When I first started looking at the implications, though, of this case, it was indeed startling to me because, put succinctly, if this ruling restricts the use of these nationwide injunctions, it could have implications for other constitutional rights. I mean, not just birthright citizenship, gun rights were brought up in court today. Can you explain some of that?
Absolutely. I mean, the nation here has a constitution, right? The Constitution isn't state-specific. The Constitution isn't district-specific. The Constitution isn't even federal circuit-specific. If you think about the gun context, the example that was raised in court today is, imagine a scenario where a different president, so you take this out of the results-oriented or the partisan lens of thinking about Donald Trump and thinking about birthright citizenship. Imagine a very different executive who declared by executive order that he wanted to, or she wanted to, take away every gun from every gun owner in America. And then every single individual gun owner would have to challenge that policy specifically as applied to them, or go through the process of forming a class action to do so. That's not the rule of law. That's not a constitutional right. That's the rule of law for those who have the resources to press a case. The Constitution is supposed to apply nationwide to everyone, regardless of whether or not they have the resources, the time, the energy, the access to counsel to press a case. So to your point, Paula, the concern about striking down universal injunctions is a real concern, not just in the birthright citizenship context, but in the context of our separation of powers. The Solicitor General of the United States stood in the well of the Supreme Court today and effectively declared war on the courts of the United States.
Yeah, assuming that they would not have the jurisdiction that in practice they had always have. And I want to stick with this concept of taking this out of the political realm, because do you agree that both Democratic and Republican presidents, at times do not believe that lower courts should have this power?
Absolutely. And that's the point about the principled concerns about nationwide and universal injunctions. And there's no question that we have more universal injunctions today. The practice is much more pervasive than it has been at any other point in American history. But that's really a byproduct of the fact that we also have more volume and more sweeping scope in terms of executive orders. So if the executive is issuing executive orders that change the meaning of the Constitution, that change the meaning of federal law on a regular basis, on a wholesale basis, and on a broad basis, then you're going to see more universal injunctions, because the alternative is that the law only applies if the executive agrees with it. And that's basically the exact system that the American revolutionaries fought against.
So fascinating. James Sample, we'll have to leave it there, but we'll continue to watch this case with interest. Really appreciate it.